So let's take a legal deep dive into this case. Attorney Hector Diaz joins me once again. You know, Hector, this was changing by the hour as of this morning when we were learning about it. I mean, it went from sad to just strange. You've got, the fact that they were dead for quite some time.
Right.
Bodies were found separately. Pills were found nearby. On the one hand, there's no signs of foul play, but yet their deaths are called suspicious. I mean, how is one not the other? Explain the difference between foul play and suspicious, because I almost feel like they're synonymous.
Well, I think when they went in, they get the report, law enforcement, they go in and they're not seeing any obvious signs of like a shooting, a stabbing, some kind of where it's just clear that their deaths were caused by foul play.
Okay, so that it's
Right.
like it's almost like physical.
Right.
Okay.
Signs of forced entry, signs of a struggle inside the house.
Okay.
That there would have been broken glass or the couch tossed over, something like that, right?
Right.
They didn't see that. Instead, what they found were two dead bodies, a dead dog, and then they found some really just things that just didn't add up.
Right.
I think when I heard the story in the morning, obviously really sad. I mean, who doesn't love Gene
Yeah.
Hackman? The thing that jumped out to me was, okay, this has got to be carbon monoxide.
That's
right?
what a lot of people
A lot of
thought,
people
yeah.
immediately, it was all over the internet, but there is no evidence of any kind of carbon monoxide or dangerous gas or whatever. They're still going to look at these issues, but at least those weren't predominant. They weren't discovered there on the scene.
Yeah.
And so they started looking. There were some other kind of concerns, pills
Right.
strewn out.
A prescription bottle, yes.
Some question in terms of, did they die at the same time? Did, the wife die earlier? And so they're going to take their time. They got a search warrant.
Right.
They're slowing this down, and they're going to look at the evidence. And that search warrant gives them access to the house. They can go and look areas, and they're able to recover certain evidence. Again, you really hope there isn't any kind of foul play here, that there's some explanation. But if they need to, they may look at computers here. They may look at cell phones. They may talk to neighbors. They may see, what they're going to look at their medical files. They're going to look at everything. So it's going to take some time to really dig into this.
All right. It's so bizarre. Okay. Well, our next national case involves new developments in the Menendez brothers. California Governor Gavin Newsom ordered the state parole board to investigate whether Eric and Lyle Menendez would pose a risk to the public if the two are released after nearly 3 decades in prison for killing their parents back in 1989. But just last Friday, LA County District Attorney Nathan Hackman said he opposes a new trial because the evidence the brothers put forward doesn't meet the legal standard. Here's what Hackman had to say.
Eric and Lyle Menendez had told 5 different versions of the events of what had happened. Sexual abuse in this situation, while it may have been a motivation for Eric and Lyle to do what they did, does not constitute self-defense.
Okay, so as you just heard, the sexual abuse, he believes, does not constitute self-defense. So on the one hand, this sounds like, as you heard, a major setback from the DA, but yet there's a possible chance considering what Governor Newsom just did. So explain both sides here, because it seems like a little bit of a contradiction.
Yeah, we almost see another Netflix special to explain what's going on. And so the Menendez brothers asked for a new trial. They're not going to get it. And this new DA explained why. That this whole issue of whether they were sexually abused, yes, there is some issue here, but it doesn't rise to the level of self-defense. And that's, a judge still has to rule, but he's going to oppose this. And I think a judge is going to find that there isn't a basis for a new trial.
And why wouldn't it constitute self-defense? Explain that.
So they allege that their father, over years of living in the house, they were subject to sexual abuse by their father, and I think they even allege that their mother had some issue here as well. And it's in order to allege self-defense. I'm getting very general here, but there has to be an immediacy of action here. They didn't allege that they killed their parents because they were in the throes of being sexually abused. They basically alleged that it was that because of the sexual abuse that they just felt like they were going to be killed at some point, that it was just a matter of time, and they had to beat their parents to it, and they murdered them in cold blood. And it's just doesn't fly. I think under most jurisdictions, they're not going to get a self-defense jury instruction if they go back to trial on this. And so the issue now is, can they get a resentencing?
Yes.
Right? And so the prior DA filed the motion actually saying, I think they should be resentenced. Let's talk about it. That's still pending. This DA has been really, tight-lipped in terms of whether he's going to support it or not support it. And I think he wants to wait. I think I think there's
Leave
some
it to the
concern.
judge.
He is. He's playing.
Yeah.
He's playing very much Switzerland here. He wants to just leave it to the judge. They do have a chance. They have a realistic chance, though, because of the sexual abuse allegations. So the court to consider that as mitigation and potentially make them parole eligible at this point. Okay. And if they are parole eligible, goes to the parole board. The governor has to still sign it. But I think that's the path to early release for them.
Right, it sounds like it. All right, well, we'll wait and see. Hector, thank you so much for your analysis on all 4 cases. We appreciate it. Troy?